Hello, and thank you, Your Honor, ladies and gentlemen of the jury. Thank you for taking the time from your schedule to be a part of today's proceedings. The case that we are examining here today pertains to me, Jacob Jones. I am the patient in this case. The healthcare worker, despite the specific instructions not to leave any of my detailed medical information on my home phone number, did so anyway. She violated my privacy and the instructions that were given, based on the HIPAA privacy rule that states, the standards for privacy of individually identifiable health information privacy rule establishes a set of national standards for the protection of certain health information. The U.S. Department of Health and Human Services, HHS, issued the privacy rule to implement the requirement of the Health Insurance Portability and Accountability Act of 1996, which is HIPAA. The privacy rule standards address the use and disclosure of individuals' health information called protected health information by organizations subject to the privacy rule called covered entities, as well as standards for individuals' privacy rights to understand and control how their health information is used. Within HHS, the Office for Civil Rights, OCR, has a responsibility for implementing and enforcing the privacy rule with respect to voluntary compliance activities and civil money penalties. HIPAA states when and how the patient's information is to be used. She therefore did not follow the HIPAA rules as far as they are stated to leave confidential information on my daughter's voicemail. All of my medical conditions and treatments were left on the voicemail. I asked explicitly to be contacted on my work number regarding any medical information that was needed to be communicated. This was not the first time that this has happened. There have been several other occurrences where this has happened. One example is a case that involves a nurse employed by Guthrie Clinic Steuben in Corning, New York. When the nurse learned of a patient's sexually transmitted disease, she sent 6 text messages to the patient's girlfriend, who was the nurse's sister-in-law, about the patient's condition. The patient, identified in court documents as John Doe, learned about the text messages, called the clinic to complain, and then sued the clinic, despite the clinic having terminated the nurse's employment. Among other things, the patient claimed that the clinic and several related entities had breached their responsibility under the law to keep his health information confidential. Even though this was not at the same clinic, this was still a violation of patient privacy. The clinic and the healthcare worker were not given instruction to provide the patient's information to anyone. This was a clear violation, as is with my case. I feel that the training needs to be better enforced and records need to be updated. This could have been prevented had the healthcare worker taken the time to go into my chart and read the necessary information on my profile. She failed to protect my information and also has failed to obtain a written consent form from myself to allow any phone calls to be made to any other number than what was listed. She shared my information without my consent. Based on the HIPAA law and my documented information in my chart, not only is the hospital in violation, but the healthcare worker is as well. I feel both of them need to be held accountable for this. I would like you all to consider the facts here today and determine that my rights and privacy as a patient were in violation. Thank you for allowing me to take the time to present my case. I know you will seek justice for the wrongdoing in this matter.